Hi, Gerald Cipolla of the Cipolla Law Group, which is a immigration law firm. And today I'd like to talk about a new policy that was just issued last week by USCIS that's going to go into effect on September 11th of 2018. It's a very important policy, and we're getting a lot of questions about it. And the policy is now USCIS has the discretion for its adjudicators to issue straight-out denials upon receiving an initial filing or initial petition. That's a departure from the previous policy where if USCIS needed evidence or didn't see a claim, they should issue a request for evidence. So what that means is now with the new policy, USCIS, the adjudicator, if they think a case is just frivolous or meritless, and those are the words that they're using. So frivolous means that it's not really a genuine application. It doesn't meet the legal requirements. Or meritless, same thing basically. It's not showing that a case, the elements of the case, the requirements of the case are being met. So in the past, if an adjudicator saw that the requirements aren't being met, they can give the applicant an opportunity to correct it. They would issue a request for evidence, so meaning they want more evidence submitted to meet those required elements. But now the adjudicator has the discretion to just flat out deny a case. And that's extremely important because sometimes, especially in other areas of law where you need to go to court and you need to meet a time requirement, you just submit a bare bones filing and then you'll supplement it with more evidence. You'll give another opportunity to supplement that case. And it wasn't that different in immigration. So if you're meeting a deadline, well, the client or the applicant, the petitioner, they just submit everything that they can to give themselves more time. Usually you'll get a request for evidence that may give you 87 days to supplement the filing to meet the requirements. But now you may not have that opportunity. And it's very unfortunate. Let me give it an example. We submitted a petition and it requires a form I-130A. And it requires all pages. Well, we scan everything, we copy everything, and we make sure that we have everything, and we have a lot of redundancies to make sure the petition's properly filed. Well, we received a request for evidence saying that they were missing a page of the I-130A. We double-checked our scan filing, and sure enough, it was there. But on the USCIS's side, they may have misplaced it. We don't know. But the point is, if they don't get a page of that filing, can they just flat out deny the filing instead of issuing a request for evidence? Well, this new policy memo goes into effect September 11th. So that's a really big deal because they're essentially demanding perfection from the petitioner or the applicant, whereas if they make a mistake, it could be imputed or it could be reflected to the petitioner or the applicant without an opportunity to correct it. And a problem with that is that has really real consequences for people. If they fall out of status or if a case gets denied, well, they may be put in removal proceedings. That may be their last chance. They may start to accrue unlawful presence. There's just a host of consequences, foreseen and probably unforeseen, that could happen with this new policy memo. So it's a really big deal. So what can you do going forward? Well, you know, life's not perfect, but you have to try and make your case as perfect as you can on your initial filing. It's something that we've always tried to do, but sometimes you're not always given that luxury of time. The purpose of their memo is to try and unclog their system. There's a lot of processing delays right now. And according to their memo, they want to rid cases that are just trying to buy time or filing frivolous cases to buy themselves time. And that's understandable, but if it's going to take out good cases, as part of that policy, that may not be the best solution for it, because it's going to have some real consequences for people depending how they implement this. It's unique because other areas of law, as I said, in court filings, usually have opportunities to address issues. The courts gives you due process, and in this process, or this policy memo may not be giving you the necessary due process that's under the Constitution. So we'll see how it plays out, but what you can do is try and make your filing as comprehensive, as strong as you can on the initial filing. Talk to a good immigration lawyer, do your due diligence, and get the case, and don't procrastinate. Usually acting sooner rather than later. So you're not up against a time crunch where you can't make the case good or you miss something. So stay tuned as this policy memo takes effect September 11th, and we'll continue to give you feedback as we see it. Send us your questions, like us on Facebook, subscribe to our YouTube videos, and we love hearing from you. Thank you.